Be ready. Start. Their provisions do not fetter on the powers of the appellate court to grant instant decree of divorce. The appellate court is competent to grant instant decree of divorce without reference to the time limit prescribed under this subsection. In that case, marriage took place between the parties on February 19, 1978. Since January 1980, they were living apart. However, a petition filed for divorce by consent under Section 13B of the Hindu Marriage Act is required to be kept in abeyance for a minimum period of 6 months. This is in sharp contrast with a petition for divorce by consent under Special Marriage Act, which is liable to kept in abeyance at least for 1 year. This liberalizing trend of law in the matter of granting divorce by consent cannot be lost sight of by courts in interpreting that section. But even the clause 2 of section 13B requires a court not to pass a decree for divorce before 6 months of time lapses and after 18 months of time passes from the date of filing of such a petition for divorce by mutual consent. This is the last hope of the legislature for saving the marriage. The intention of the legislature is to provide a minimum period of 6 months for rethinking of the parties. If the above timetable fixed by Section 13B Clause 2 of the Hindu Marriage Act is applied to the present application made by the parties in this case on 12th July 1985, we have to adjourn this case till January 1986 for passing a decree for divorce under that section, notwithstanding the fact that we are of the opinion that there is no chance of reconciliation between the parties who have been living away from each other for the last 4 years and are today most anxious and ready to obtain such a decree here and now. That situation raises somewhat an important legal question as to the meaning which we should attribute to Section 13B Clause 2 of the Hindu Marriage Act. That question is whether the legislature intended to Section 13B Clause 2 of the Hindu Marriage Act should be treated as mandatory provisions of law, or the legislature intended that section to be treated merely as a directory provisions of law. We have already noticed the language of Section 13B Clause 2. On first impression, it is not impossible to hold Section 13B Clause 2 to be mandatory. They further stated that the judgment and decree dated 29 September 1980 was passed in their favor, wherein it was clearly held by the sub-judge first class that Srimati Ram Kaur did not execute any will in favor of Srimati Pushpa Singh. The said judgment and decree was confirmed by then Additional District Judge Ludhiana on 7th April 1983. Srimati Pushpa Singh had taken part in those proceedings as attorney of her husband Iqbal Singh. It was further averred that after having lost the litigation, Srimati Pushpa Singh fraudulently obtained an ex parte decree from Sub-Judge Ludhiana by giving wrong addresses of the decree holders regarding which an application under Order 9, Rule 13 CPC for setting aside the ex parte decree had been filed, which was pending. They next stated that Srimati Pushpa Singh had even filed an application under Order 1, Rule 10 CPC for becoming a party during the pendency of the case for passing the final decree, which was dismissed by the Additional Civil Judge Ludhiana, and it was clearly held that the decree in favor Srimati Pushpa Singh was nothing but a complete forgery. Since Srimati Pushpa Singh had sold the property to the objectors during the pendency of the proceedings for passing the final decree, so the sale deeds were hit by the principle of les pedens, that is section 52 of the Transfer of Property Act, and as such the objections should be dismissed. The executing court dismissed the objections vide judgment dated 2nd May 2001. The objectors filed an appeal, which was also dismissed vide judgment dated 19 October 2001 by the Additional District Judge Ludhiana. Still dissatisfied, the objectors have filed the present revision petition. I have heard counsel for the petitioners, Mr. Arun Jain, advocate, along with Mr. M.L. Sagar, advocates, Mr. Amit Rawal, advocate, counsel for the caveated respondents, and carefully gone through the file. The facts of the case, as stated by the decree holders respondents, are that Srimati Ram Kaur expired on 16 June 1972, while her husband Hari Singh expired on 19 February 1977. After the death of Srimati Ram Kaur, the original owner of the suit property, it was inherited by her all natural heirs. A suit for partition was brought by her legal representatives. Iqbal Singh, husband of Srimati Pushpa Singh, contested the suit through his wife, who acted as his attorney. The will set up by Shri Iqbal Singh and Srimati Pushpa Singh, purportedly executed by Srimati Ram Kaur, was disbelieved, being forged and a fabricated document.